Looking out my back door. Looking out my back door. Let's see your channel. That way I can check to see who people are. And I'm going to defer to the master on how one puts the cocks to bed. Juan Galt is the master of that. One might say he is the masturbator. All right, I have notified my Discord, as I am so often told I should. I'm going to assume that everybody can hear and see me, although I don't know why you would want to. But we are going to start with share the screen. We're going to start with this nonsense. Hello, Michelle. Jeff is a master debater. Nice. John Hanzo says I have multiple cocks. Yes. Thumbs up to you, Mirrors. Your AI is here by special appearance only. And I am not tilted today. No, I'm usually not tilted. I'm just not hyped up. I'm actually drinking coffee at 5:45 at night because, well, it's been a long-ass week. It's been a long-ass week. All right, so let's listen to what this idiot says.
You want to film the police. This is your daily friendly reminder. Before you start filming police, you look right into the camera lens and you say, I am filming police because I'm protesting police.
So ignoring the music that he bought, the stirring music that he bought to put behind himself while he's filming at what appears to be like a gas station or something. Let's pause to consider what that would be. If you looked at the camera and you said, I'm protesting the police, what would that be? Well, if you're going to try to offer that as evidence that you were, in fact, protesting the police, well, I must have been protesting the police because I looked into the camera and I said I'm protesting the police. That's what we like to call hearsay. And hearsay is what we like to call inadmissible. So no, you'd actually be better served by putting into your verified complaint not the conclusion that you were protesting, but the various actions that you took to protest, if that makes sense. So I was marching and chanting "all cops are bastards" as I filmed or what have you. Here's the forehead. Okay. Sorry, John Clark. I don't even know. Oh, are you talking about Chili? Is Chili's hair thing on his forehead? You pay more attention to it than I do, I guess. He doesn't look particularly healthy. He looks like an old man to me, but that's just me. Anyway, yeah, so it's not really useful for anything. It's not going to do anything for you. But why? Okay, let's ask the 20-year constitutional law scholar why. Why would you say that into your camera? And it says you want to film the police. This is your daily friendly reminder. Nivens versus Bartlett 2019. Well, before I get too far, let's just let the cat out of the bag that it's Neves versus Bartlett, not Nivens. But we'll see if he corrects that.
And the reason why is that gives you a lot of exceptions.
A lot of exceptions. So one of the cornerstones of Sovsidery is that there are magic words out there. There are magic words that you could say that are going to remove the authority of the courts or remove the authority of the cops, etc. And here's the sorry fact is that there aren't Well, there are some magic words. Let's take some magic words. One magic word is I'm invoking my right to remain silent and then shutting the fuck up. Those would be magic words. I want an attorney. Those would be magic words to stop an interrogation, provided, of course, that you shut the fuck up afterwards. Is something about Mary hairdo? Oh, it's like the spooge in the hair. Well, I mean, he's short, so he has to make up for his shortness with elevated hair. But there are no magic words. Like what he's thinking, there's no magic words. But let's hear his explanation for why these words are magic and why they give you exceptions, whatever those are.
2019 case of Nivens versus Bartlett.
See, he even says Nivens versus Bartlett, and he has it on the screen of Nivens versus Bartlett. Like, is this the guy that you want advising you on your lawsuit against the police, on how to protect yourself in a lawsuit against the police? I mean, is this really who you want giving you that advice? A guy who can't remember Neves? I don't know.
Supreme Court case that came out of Alaska. Neil Gorsuch would write in his majority opinion.
Most Supreme Court cases, they come out of Washington, D.C., because that's where the United States Supreme Court is. So it came out of the United States Supreme Court. Now, the underlying case came out of Alaska, yes, but that's not really relevant information. Chile likes to throw in irrelevant facts. Like, it came out of Alaska. Like, who the fuck cares, bro? It came out of the United States Supreme Court. That's the operative fact.
That we must allow an.
And why does he care that it's Neil Gorsuch? I mean, it's good to note that it's in the majority opinion, whatever he's trying to say. But like, who cares who wrote it?
Exception for people who protest the police, that if they step in the road, they won't get arrested for jaywalking.
Is that what he says? Oh, you can't see that. So I'm on Neves versus Bartlett. Can you guys see my little search tab? You can't. Damn it. Well, anyway, if you go there and you Control F, which you probably can't see, I'm going to move this over here so I could see, if you could see what I'm doing. So if I Control F, nope, not there. I'll do it on this screen. Control F, you can't see. God damn it. Anyway, if you type exception in there, nothing comes up. So you saw excused, E-X-C-E, nothing. So there is no exception in there. So I don't know exactly why he's talking about exceptions. But it does talk about jaywalking. And for example, here we go. For example, at many intersections, so this is the example that the Supreme Court is using. The Supreme Court isn't saying you can't get arrested for jaywalking if you're protesting. The Supreme Court is saying, here is an example of why you might be able to prevail on a retaliatory arrest claim. And the example is, at many intersections, jaywalking is endemic. It happens all the time, but rarely results in an arrest. If an individual who has been vocally complaining about police conduct, not who looked into their camera and said, I'm protesting the police, but who has been vocally complaining about police conduct, is arrested for jaywalking at such an intersection, it would seem insufficiently protective of the First Amendment rights to dismiss the individual's retaliatory arrest claim on the ground that there was undoubted probable cause for the arrest. In such a case, because probable cause, blah, blah, blah. So what you have to do is you have to look at how similarly situated individuals who aren't engaged in the same sort of protective speech have been treated. In other words, if you cross the street and you've been shouting all cops are bastards, if you jaywalk shouting all cops are bastards and you get arrested, but another guy who walks across the street who hasn't said anything doesn't get arrested, or if he walks across the street while shouting Blue Lives Matter, if he doesn't get arrested, then you could theoretically make a case for retaliatory arrest. Theoretically. Do you know that when a dog audibly scratches his ear, he's ignoring me? So we have a lot of foxtails up here, and Patty is just cruising height for foxtails, and he gets them in his ears, and so we have to spend a shit ton of money on vets to get those fucking things out. So no, he just his ears bug him all the time. F12, says John Clark. I don't know what you're talking about. So yeah, so that's the operative theory behind it. That you don't get exceptions, and there's no special magic words. Now you can kind of see how this was in action in Ballantine versus Tucker. This was originally tried before Nivens versus Bartlett was argued and the decision came out. So after Nivens versus Bartlett, it went back to the trial, and then it came back up and it was appealed. And in this particular situation, it's associated with cop block. So they were out there and they were using chalk to write anti-police messages, right? Now, normally people who write in chalk don't get arrested. So the Supreme Court has also carved out a narrow exception for cases where officers have probable cause to make arrest, but typically exercise their discretion not to do so. For example, if an individual who has been vocally complaining about police conduct is arrested for jaywalking, an offense that, quote, rarely results in arrest, end quote, it would seem insufficiently protective of the First Amendment rights to dismiss the individual's retaliatory arrest claim on the ground that there was undoubted probable cause for the arrest. To be sure, the Nivens exception applies only when a plaintiff presents objective evidence, not subjective, objective evidence. Anybody who looks at this thing is going to come to the same decision, not how you feel about it, not how somebody else feels about it, but objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. Showing differential treatment addresses the causal concern by helping to establish that non-retaliatory grounds were in fact insufficient to provoke the adverse consequences. So you can see the arguments that he makes. The Detective Tucker, that's the bad guy in this particular situation, contends that the plaintiff's claims do not fall within the Nivens exception because the evidence does not support the allegations that they were singled out based on a retaliatory motive. But plaintiffs presented objective evidence showing that they were arrested while others who chalked and did not engage in anti-police speech were not arrested. So they actually showed the court, they presented evidence to the court that person X did not protest the speech or protest the police, but was engaged in First Amendment activity by chalking on the sidewalk, was not arrested. We were protesting the police. We used chalk on the sidewalk. We were arrested. During discovery, Metro produced records indicating only 2 instances in which chalkers were suspected of or charged with violating Nevada's graffiti statutes. This is even a case out of Nevada. You can't go wrong with that. In these 2 circumstances, only 1 individual was cited, not arrested, for chalking on public property. There is no evidence that anyone besides plaintiffs has been. There's no evidence that anyone besides the plaintiffs has been arrested for chalking on the sidewalk. Additionally, the plaintiffs presented evidence that other individuals chalking at the courthouse at the same time as the plaintiffs were not arrested. This is the kind of objective evidence required by the Nivens exception to show that a plaintiff was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. So you can see what you kind of have to show. So in the case of the sidewalk chalkers, they had to show that no one else was getting arrested for it. At the same time, they were doing it. At the same time that the plaintiffs were chalking, other people were chalking, and they weren't arrested for it either. Only the plaintiffs were arrested for sidewalk chalking. And he goes on to say that he put the fuck the pigs and fuck the cops in the arrest warrants just to show the judge the kind of language they were using, etc. However, the possibility that other inferences could be drawn regarding the officer's motivations that would provide an alternative explanation for the officer's action does not entitle them to summary judgment. This is an issue for the trier of fact, not for us to resolve. So what happened is the plaintiffs presented enough evidence that it wasn't clear. I mean, if it's just clear on its face, or if they were unable, so that the burden is on the plaintiffs to show that it could be, like reasonably could be, retaliatory. They have to present enough evidence to show that it probably is this thing. And then the burden shifts to the defendant to show that no, it was not in fact retaliatory. But here they weren't able to show that because everything that the detective said, it could go either way. I mean, oh, you say you put the messages that they were chalking into the request for arrest warrant to show the judge so the judge could evaluate the First Amendment concerns. That's great. But it could also be you put it in the request for the arrest warrants because you thought it was reprehensible language and you, Mr. Cop, wanted to retaliate. So the trier of fact, as the district court observed, could very well credit or disbelieve Detective Tucker's explanation. Certainly there's a general dispute of material fact for plaintiffs to survive summary judgment, as the evidence does not permit only one reasonable conclusion. So that's that is in a nutshell the Bartlett versus, or the Nivens versus Bartlett test and how it's applied. The problem with the folks out there who are filming the police is they have to show that people who are doing the same things that they're doing are not getting arrested if they're not actively against the police. The problem is that, and it is a problem, the problem is that really only cop watchers go out there and do the kind of recordings that we see. And so it's a narrow field of people who engage in this particular style of protest, whether or not they're for or against the police. Now, I would posit to you that if you are pro-police, it is for your side's benefit if you record the police. I recommend everybody record the police because if you are pro-police, your videotape, your recording, your cell phone footage might actually exonerate the officer because, you know, his body cam only catches one angle. Having another angle might be the difference between is the gun pointed at Wallace's head or is it not pointed at Wallace's head? So I encourage even pro-police people to record the police. I encourage everybody to do it from a safe distance. I encourage everyone to not defy the officer's orders if the officer tells you to move back, because you can beat the rap, but you can't beat the ride. And if the officer tells you to move back, well, if that violates your rights, then you have enough by allowing him to move you back, you still have enough to sue on. So you don't have to get arrested to file a lawsuit. And I suggest you not get arrested to file a lawsuit. Your attorney will thank you. I think that is probably about it on this idiot. Oh, no, we're only halfway through. Well, isn't that a bunch of bullshit? All right, let's go.
That's why you always look right into your camera when you start and you say, I'm protesting police.
Again, that'd be inadmissible. It would be hearsay. It would not be useful. It would actually still be more useful to you to say in your verified complaint, or for you to say in a signed declaration or affidavit, whatever. It would be way more useful for you to say it there than into your camera, because it is still hearsay.
That's why I'm filming this interaction. Then if you step in the road and the cop arrests you, you got him in a 1983 civil rights violation.
Do you though? I mean, do you? I mean, whew. What if there's a clear history of a lot of jaywalking arrests being in that intersection? What if he arrests you for something besides jaywalking? What if you go out there and you actually interfere with the interaction between the police and the person who's being stopped. What if you go out and interfere in that, and the officer gets you for obstructing justice or resisting obstruction, delay, whatever the local statutory reason for an arrest would be? They can arrest you for more than one thing, and it's not what the Nivens test is designed to do. It's designed to figure out, okay, probable cause is a big bar. Like, if the cop had probable cause to arrest you, that's a huge bar. Now, in order to get past the presumption that the cop had probable cause, so he's golden, to get past that, you have to show that but for your speech, you would have not been arrested. That's what you have to show. But for your speech, you would have not been arrested. So if you had walked out into the road without filming the police, would you have been arrested? You'd have to show that. And if you're the only person out there who's doing that, that makes it really hard. If you're the only person who's doing that kind of activity, if there are no similarly situated individuals, then how are you going to prove that similarly situated individuals aren't being treated that way? How would you prove that? That'd be a tough one. And a genius attorney like Delete Laws doesn't have the answer, because he's never made it fucking past summary adjudication. So coffee. I love you so much. We're almost done, kids.
And it's a smack dab home run winner.
See, there's also a rule. It's in the rules of professional conduct. It's in the model rules. California has adopted them. An attorney cannot guarantee an outcome. It's literally an ethics violation if an attorney guarantees an outcome. Why? Well, because no one can know. There's always your version, their version, and the truth. There's always those three. You know what? Don't push me. If I am at the point where I have to drink coffee, I will not accept slander of coffee, sir and or madam. So anyone who is stupid enough to guarantee an outcome when judges won't guarantee an outcome. So, like, one of the things that I like doing for my clients, especially on complicated matters where they don't really understand, they don't, like, you tell your client, look, man, like, we've got some weaknesses. We've got some strengths to our case, but we've got some weaknesses, and maybe we don't want to run headlong into trial, because it's going to come down to, do they believe you or do they believe him? And that's, who knows which way it's going to turn out, right? So one of the things I like to do is I like to mediate, and I typically like to use retired judges. One I really like to use is a retired justice from the California Court of Appeal. And the reason why I like doing that is because he will, like, if he says, like, look, there's a problem, like, here's the holes in your case, you might want to think about settling this, the client will take it more seriously. But even him, like, I've trained this particular justice. I'm going to say I've trained him. I've done, I don't know, about 10 or 11 mediations with him, and all of them so far have wrapped up successfully. But one of the things that I've gotten him to do is give me odds. Like, okay, so, Your Honor, with everything that's in our mediation statement and everything that's in their mediation statement, what do you think our odds of prevailing are? And what do you think their odds of prevailing are? And I've never heard him say 100%. And I would be surprised if he ever said 100%. And, a lot of times, like, he'll be like, okay, your odds of prevailing are like 66%. And what are their odds of prevailing? Their odds of prevailing are like 75%. And you're going to say, well, that's more than 100%. Well, but that's kind of the way it works. If you're looking at this stuff, it's really hard. Like, even a retired justice from the California Court of Appeals won't be able to accurately predict. There's always that X factor. And so this chucklehead saying that it's a slam dunk home run, it's a smack dab home run winner. Well, I mean, press X to doubt.
I am protesting the police. So you want to?
So that was pretty stupid. Again, any statement that you made, an out-of-court statement that's offered into evidence for the truth of the matter asserted therein is hearsay. That's the my generalized definition for hearsay. And you looking into the camera is an out-of-court statement. And if you're offering it to the court for the truth of the matter asserted therein, i.e. that you're protesting, it is definitionally hearsay. Now, opposing party can bring it in, and because there's an exception to the hearsay rule for a statement by a party opponent. So if it hurts your case that you're protesting, opposing counsel can bring it in, or opposing party can bring it in. But you can't use it to help your case. But my attorney told me shut the fuck up. He was wrong and I'm in prison. Fucking dick. My attorney told me shut the fuck up. He was wrong. No, you will never. That I'm going to press X to doubt that. If your attorney told you to shut the fuck up, if you did shut the fuck up, then nothing you said could have hurt you. So his advice was excellent advice. Shut the fuck up. Unless you're CJ Grisham, in which case your fucking stupid short ass should go over and talk to the police and tell them all about how you pointed guns at unarmed motherfuckers. What a goddamn buffoon. I'm not going to say he's going to be charged with anything because police generally don't like to enforce crimes against homeless people. But yeah, CJ Grisham's a fucking idiot. Well, I'm going to go run talk to the police. Anyway. There was a minor update in Springer. The court did some changing around. There is a new amended order denying plaintiff's request for a temporary restraining order. They address some further facts. They do a little bit more. The court does a little bit more analysis. And where do they start? I think this is new that the court added into it. But anyway, long story short, I had talked about the factors that the court was likely going to rule against him on, and the court only addressed one factor because all the court has to do is find that one factor will prevent you from winning, and the likelihood of success on the merits is still the factor that the court found weighed against him. And the new rationale is that local rules require you to cite authority in support of legal positions advanced, and apparently Springer's attorney did not. So attorneys are humans. His attorney is better than Decastro by a long shot. Gotta love comparators. I don't know what that means. So, long story short, Freeman is still on a quick train to be done. So there is still this order to show cause. Either Springer has to move for a default, or it's going to get dismissed for failure to prosecute. I don't know really what Freeman stands to gain at this point. The reason why I say that is because the court has already said, I don't see you prevailing on the merits. The court's already said that. The court's telegraphed its move. And now it is a magistrate who said that, but a magistrate's going to look at it the same way a judge is going to look at it. I looked at it and I thought that he's going to have a real problem prevailing on the merits. And especially now that I've seen the response from the Seventh Judicial District Court of New Mexico, whatever the hell it's called. Now that I've seen their response, I'm even more inclined to believe that he'll lose on the merits. Except he could move for default and see if he can't win on the default. He'd still have to convince the court to give him a default judgment. So we'll see about that. What's next? Next is Decastro versus Wagner. What have I not covered? Did I do the response and the reply? I don't think I did. Alrighty. This is Lawrence County's response to his motion to vacate and file a second amended complaint. His second amended complaint was pure fucking garbage, by the way. I just want to say that for the record. It was pure fucking garbage. Just adding in more useless things doesn't fix the problems with his pleading. On August 3rd, this case was closed. Despite it being closed, plaintiff filed 2 motions for reconsideration, a motion to correct the judgment, and now a motion to vacate and leave to file a second amended complaint. For the reasons set forth below, they want him to deny the court to deny it. Motion to vacate. Plaintiff requests this court grant leave to file a second amended complaint after vacating judgment under Federal Rules of Civil Procedures 59 and 60. A court may grant a motion to amend or alter judgment under Rule 59E if there is clear error of law, newly discovered evidence to prevent manifest injustice, or due to an intervening change in controlling law. The function of a Rule 59 motion is not to renew arguments that have already been considered and rejected by the court, or to proffer a new legal theory or new evidence to support a prior argument when the legal theory or argument could, with due diligence, have been discovered and offered during the initial consideration of the issue. Now, this, with due diligence, could have been discovered and offered. It doesn't take into account, it doesn't offer grace to someone who is pro per. It's that standard is, could this pro per person have found this particular point of law or this particular bit of evidence prior? If yes, then they lose. If no, then fine, we'll go forward. Rule 59E allows for reconsideration. It does not permit parties to effectively re-argue a case. Moreover, motions under this rule are extraordinary and should be sparingly granted. That is correct. The standard for granting a Rule 60 motion is significantly higher than the standard applicable to a Rule 59 motion. A court may provide relief under a Rule 60 motion in instances of mistake, inadvertence, surprise, or excusable neglect. Now, this isn't like normal stuff, like what you're thinking. Oh, I made a mistake. I didn't make the right argument. That was a mistake. Mistake is like I mailed my response. They got a default judgment on me, or they got a default on me because I mailed in my response to the court and I put the wrong address on it. I instead of like 5830 whatever Faircourt Lane, I did 5380 Faircourt Lane. That's a mistake, right? Inadvertence, like there have been cases where like an attorney tried to file the case. It was rejected because of like a clerical error, things like that. Surprise. I don't have a good example of this. Excusable neglect. One of these was where an attorney got ill and wasn't able to respond, had an accident or something. So that's the kind of things that they're looking at there. They're looking for things that are kind of beyond your control. Well, aren't you fucking special? Aren't you fucking special with your fancy schmancy language? Fancy schmancy motherfuckers. Why are all of you West Virginians so puffed up with yourselves using big words? Fuck YouTube, and there's shit inside chat. At least Kimmy gets delivered with wheels. I don't know what we're talking about. Is someone going to buy me a Diet Klondike bar? That's a rough one, Yuri. Good luck on that one, bro. All right. Then 2, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59B. Again, that's not something. That's something that like you should have found out. Fraud, misrepresentation, or misconduct by opposing party. There's a difference between intrinsic fraud and extrinsic fraud. Like saying that, oh, well, opposing party lied to the court. That is intrinsic fraud. And no, that's I get them backwards. But like if you're saying that they lied to the court, oh, he lied under oath. That's not what the court's talking about here. This kind of fraud is like where like you get a default judgment, and you get that default judgment because you have lied on your proof of service of summons and said that you served them and you didn't. And then you lied on your motion for default. And then you lied on your motion for default judgment. It's fraud on the court. It's saying that you did something as far as the court procedures are concerned, not that oh, you should redo this judgment because homebro lied on the stand. That's a total different thing. The judgment is void. Well, that's a pretty rare thing. The judgment has been satisfied, released, or discharged. It is based on an earlier judgment that has been reversed or vacated, or applying it prospectively is no longer equitable, or any other reason that justifies relief. Importantly, a Rule 60B motion does not afford a litigant a second chance to convince the court to rule in his favor by presenting a new explanation, new legal theories, or proof. It appears that plaintiff is claiming his motion to vacate is warranted due to newly discovered evidence and due to fraud. In this case, it would be fraud of withheld evidence because the prosecution has a duty, it'd be a Brady violation if the prosecution doesn't turn over all evidence, either that the prosecution is going to use damning evidence and exculpatory evidence. They have to turn over all evidence to the plaintiff. Now, that's a completely separate action from this lawsuit, where it is not the state of Nevada against Decastro, but Decastro versus, hold on a second, the state of Ohio versus Decastro. This is Decastro versus the city of Ironton and the county of Lawrence. So it's different. You have different people on both sides of the V. So what the prosecutor did does not taint what the defense did. The defense, in this case, doesn't have that same duty. Plaintiff claims that while working on a new complaint, plaintiff's newly hired forensic evidence experts discovered on September 7th that the times of the events were incorrect in the original and first amended complaint. Plaintiff further alleges, his newly hired forensic experts, let's just pretend that this is a thing. Well, could he have hired those experts prior to September 7th? Could he have hired them back when he filed this, in like November or December, a long ass time ago? He could have hired them way back then. He didn't. So this doesn't fit the newly discovered evidence, because with reasonable diligence, it could have been discovered in time to move for a new trial. Even if it is good, it still doesn't fit that bill, and it's not good. Plaintiff further alleges that he could not have reasonably determined this, as plaintiff is not an expert, and plaintiff could not have been expected to hire an expert prior to discovery, if at all. Well, that's also bullshit, because you definitely can hire an expert prior to discovery. However, plaintiff could have hired a forensic expert when he amended his complaint for the first time in September of 2022. Despite claiming this is, quote, new evidence, end quote, plaintiff with due diligence could have discovered this information prior to this court's ruling on defendant's motion to dismiss. That's precisely correct. Nonetheless, this newly discovered evidence fails to change the fact that the allegations set forth in the first amended complaint did not hinge upon the time that the incident occurred. The time difference of couple minutes, if true, fails to establish that the claims set forth in the amended complaint sufficiently allege a constitutional violation occurred as a result of defendant's actions. Most importantly, the newly discovered evidence has no impact on the claims against the Lawrence County defendants because the aforesaid defendants did not effectuate plaintiff's arrest. Accordingly, the Lawrence County defendants respectfully request this court deny plaintiff's motion to vacate. And again, the operative issues whether or not the arresting officer for the city of Ironton and the arresting officers, the operative issue is, did they have probable cause? Well, the clock in there said it was past time. The city employees were saying that you have to leave because we're closed, and Chili didn't leave, and everything looked like it was past time. So even if he could prove that that Google's clocks are more accurate or what have you, even if he could prove that, it still would not defeat the fact that the police had probable cause. Who are these experts? They're probably figments of Chili's imagination. Probably. So the motion for leave to file a second amended complaint pursuant to FRCP 15A, a court may permit a plaintiff to amend his complaint if justice so requires. However, the decision regarding whether to grant permission to amend the complaint is left to the sound discretion of the district court. When determining whether or not to allow a party to amend the complaint, a court should consider the delay in filing, the lack of notice to opposing party, bad faith by the moving party, repeated failure to cure deficiencies by previous amendments, undue prejudice to the opposing party, and futility of amendment. In this case, almost all the factors weigh against permitting plaintiff to file another amended complaint. He filed his original complaint on April 13th, 2022. On May 11th, 2022, the county defendants filed the motion to dismiss for failure to state a claim. Plaintiff failed to file a response to the motion to dismiss, and as a result, the court issued an order to show cause. The order to show cause stated he had to show cause or file a responsive memorandum on or before July 22nd as to why the county defendant's motion to dismiss should not be construed as unopposed and granted. Plaintiff failed to file a response to this court's order to show cause or file a responsive memorandum by July 22nd. On August 11, plaintiff filed a response to this court's order to show cause. The aforesaid response provided that plaintiff until July 27th did not receive any filings in this matter. On August 15th, the court granted plaintiff a 30-day extension. Plaintiff filed his first amended complaint on September 15. In the amended complaint, plaintiff admitted Lawrence County defendants that were named in the original complaint and the causes of action against them. 5 days later, a motion to dismiss was filed. Plaintiff once again failed to timely respond, and on October 24th, the court entered order to show cause, requiring plaintiff to show cause in writing, yada yada. The order further provided that plaintiff may also satisfy the requirements of this order by filing a responsive memorandum to defendant's motion by the deadline. Failure to timely comply with this order will result in the pending motion being granted as unopposed for the reasons stated therein. Plaintiff once again failed to respond to the order to show cause, and as a result, on December 6th, the court granted defendant's motion to dismiss and closed and terminated this case from the court's active docket. On December 7th, plaintiff filed a motion for leave to file a response 2 days late. Attached to the motion for leave was plaintiff's response in opposition, yada yada. The court granted it. After the case was reopened, plaintiff failed to address the argument that was presented multiple times by the county defendants regarding the admission of the aforesaid defendants. Plaintiff never attempted to file a motion requesting leave to amend his complaint regarding the aforesaid issue. However, plaintiff does claim that he requested leave to amend prior to dismissal at opposition 39. Plaintiff's alleged, quote, request, end quote, to file an amended complaint was merely a sentence stating the following: if the underlying facts were lacking, which is all that is required of plaintiff at the pleading stage, he should be given leave to add them. Thus, plaintiff's request as memorandum in opposition is not a proper motion. That is correct. Moreover, plaintiff was given ample time from April 22 until this case was closed in August of 23 to file a second amended complaint. His motion for leave comes a year and a half after he filed the original complaint and over a year after he filed his first amended complaint. He's not offered any explanation or basis for his belated request. In fact, he waited until this court ruled on the Lawrence County defendant's motion to dismiss and the city of Ironton's motion for judgment on the pleadings before attempting to remedy the deficiencies in his amended complaint. The fact that plaintiff elected not to amend his complaint when he had the right to do so in response to defendant filing the motion to dismiss also weighs against allowing defendant to amend his complaint now and, in essence, take a second bite at the apple. Accordingly, the court denies his request to file a first amended complaint in this matter. So this is a slightly different situation. So in where they're quoting here, you can file a first amended complaint as a matter of right once you receive a motion to dismiss. The first amended complaint as a matter of right. This would be his second amended complaint. He did not have the opportunity to file it as a matter of right. So this is a little out of place. This is a little lacking. Am I supposed to know what the fuck's going on? I don't know what's going on. Well, if you need a hug, Logan, let me know. I'll let you use your mouth to hug my cock. The Sixth Circuit previously stated the following: an open request for the court to permit amendment to cure deficiencies once the court identifies those deficiencies will not defeat a meritorious motion to dismiss pursuant to 12b-6. Had the plaintiff filed a motion to amend the complaint prior to this court's consideration of the motion to dismiss and accompanied that motion with a memorandum identifying the proposed amendments, the court would have considered the motion to dismiss in light of the proposed amendments to the complaint. The court would not have dismissed this action had it been convinced that the deficiencies in the complaint could have been cured by the proposed amendments. Absent such a motion, however, the defendant was entitled to a review of the complaint as filed pursuant to 12b-6. Plaintiffs were not entitled to an advisory opinion from the court informing them of the deficiencies of the complaint, and then an opportunity to cure those deficiencies. So what they're arguing about here well, you know, my high school nickname was Needle Dick the Bug Fucker, so I guess that's not unfounded. So what they're saying here is that that it's essentially frowned upon to wait until after the court grants a motion to dismiss to ask for leave to file an amended complaint. And that is true. In this case, their motion to dismiss, reply, response, alerted plaintiff in the alleged deficiencies of the amended complaint. The deficiencies of plaintiff's first amended complaint were not only highlighted by the Lawrence County defendants, but the court also brought the issues to light. Quoting, under these circumstances, leave to amend yet again to correct deficiencies that were plainly highlighted for plaintiff prior to his last amendment is properly denied. Simply put, justice would not be served by granting plaintiff a third, quote, do-over, end quote. As a result, justice does not require granting plaintiff's motion for leave to file another amended complaint. The parties have fully argued the merits of a 12b-6 motion to dismiss, and this court has issued an opinion resolving the motion. It is a stretch to say justice requires granting leave to cure the complaint's deficiencies as identified in the adversarial pleadings and the district court's order. So you can't say it's required. The court isn't obligated necessarily. Small world, it's not just a world that's small, brother. It's not just a world that's small. Oh shit, nickname brothers, what a coincidence. Nice. There's a bunch of us needle dicks out there. Actually I'm more built like a tuna can. I'm only like this long, but I'm like that big around. That's the reality. It looks like a bundt cake when it's cold. I amuse myself. So it's not required that the court grant it, but it's still left in the sound discretion of the district court. So the district court could still grant it. It's just not required to. The claims set forth in the second amended complaint are based on the same factual allegations as the original complaint. Plaintiff has exhibited undue delay and bad faith by waiting until this court ruled on his positive motions to file his motion for leave to file the second amended complaint. Plaintiff repeatedly failed to cure deficiencies that were highlighted by the Lawrence County defendants and this court. And lastly, by reopening the case and permitting plaintiff to file a second amended complaint, it would cause undue prejudice to Lawrence County defendants. And there you go on that. So then our erstwhile ignoramus has filed his reply. You got to reply. I mean, never leave a reply on the table. So Jose responds, yada, yada. With the introduction, I filed a motion for reconsideration due to legal or factual error in the decision or to dismiss, or in the legal fact, due to the court's error, or due to excusable error or neglect of plaintiff. Well, so you're always 99.9% of the time, you're going to lose by saying that the court just got the decision wrong. I mean, that's a long road to hoe because the court doesn't operate in a vacuum. The court's seen your arguments. The court's had law clerks go through your arguments. The court's seen opposing counsel's arguments. The court's had that law clerk go through it. The court itself, the judge or magistrate, has also most likely gone through both arguments. And so you have a consensus of the law clerk, the judge or magistrate, and opposing counsel have all come to the same conclusions, that you were fucking wrong. Your odds of prevailing are somewhere in the slim to none range, at least as far as enjoy, Matto, enjoy. So you're not going to convince the court was wrong. You might win on appeal, but you're not going to convince the court was wrong. Just take that to the bank. Defense filed in opposition, mostly misstating the facts. I don't know why Chile persists in doing this. They were making a legal argument, and they cited to the record for like when things were filed. I don't think you're going to win by saying they're misstating the facts. This is law in motion, as in your motion is based on the law. Now, admittedly, you start off with the facts, but they're not misstating facts here, son. Defendants mistakenly argued the plaintiff didn't argue any valid grounds for his Rule 59 motion. They didn't argue that. Did they argue that? Oh, yeah, they did argue that. My mistake. Oh, nice. He actually cites to it. This is false and not represented in the pleadings, whereas your citation. And again, their argument, this is not a factual argument. This is a legal argument. This is a legal argument, not a factual argument. This is false and not represented in the pleadings. Plaintiff argued errors in law, errors of fact, abuse of discretion, and excusable error by the plaintiff. Motion sections A to G. Motion sections A to G. So his points and authorities, he has A, B, C, D, EFG? I don't know. No adequate state remedy. Defendants mistakenly argued that plaintiff was both provided valid state remedy and also never argued he wasn't. Defendants mistakenly argue that plaintiff was both provided a valid state remedy and also never argued he wasn't. Defendants mistakenly argued that plaintiff. Well, let's go back to the opposition. Opposition at 9. Opposition at 9. What, page 9? What the fuck is opposition at 9? Fucking state remedies. We're looking for there's nothing about state remedies in here. What in the fuck is going on? Did Chili have a mini stroke or something? I don't know what's going on there. There's no arguments about state remedy in the opposition, and just saying it's fault. I don't. First Amendment complaint at 16, ECF number 32 at 24. I don't really care, I guess. An amendment would not be futile. So this is the patented nope defense. And so that was garbage. That was a waste of 2 pages of that. So prediction time, I'm going to guess that the court will probably not grant Chili's motion. Now, if he had actually prepared a complaint that would survive a motion to dismiss, I would suggest to you that the court probably would grant it. But since his second amended complaint is just garbage, I don't see why they would. So I'm going to go with probably not going to grant it. I mean, it wouldn't be outside of the realm of possibility if they do grant it, but my best guess would be they don't grant it. And they've also given him a lot of rope to hang himself with, so I don't know why they would continue down that path. All right. So nothing here in Decastro. He's filed an appeal. I guess I probably could look that up at some point in time, but I'm not really particularly interested in it. He's not going to win on appeal. I'm just going to tell you, he's just not going to win on appeal. The younger abstention doctrine is so strong. He's not going to win on appeal. The court is not going to overturn the younger abstention doctrine. He'd have to go all the way up to the Supreme Court and get the Supreme Court to decide that the younger abstention doctrine doesn't apply anymore. So, I mean, it's just not happening. So let's look at Wallace. What do we got going on in this shithole? Did I cover these? I think I covered this one, right? There's been no service on the state of Nevada. So they're going to dismiss it if he doesn't file a proof of service. I think I did this one, right? The motion to stay. Can someone in chat tell me what is he appealing? He's appealing the younger abstention doctrine. He doesn't think that the younger abstention doctrine applies to him, is what he's appealing. So can someone tell me if I already covered defendant's motion to stay discovery? all these shitty motions blur together. I don't know if anybody remembers if I did or didn't. According to Chile, just uttering words make it so. I guess that's what's happening in this filing. Yeah, the nope defense. Without a condom, you're going down the rabbit hole of parenthood. Not my circus, not my monkey. He's appealing the older, not the younger abstention doctrine, but the older one. Thank you. Good thing for you, I get a shit ton of street credit I can co-sign for you, but I don't go lower than 2.3% on my street credit. I mean, that's a pretty good rate. That's a pretty good rate for borrowing street credit, GMK. What you can do is actually you can borrow his street credit at 2.3%, and you can then re-loan that out at like at least 4.5%, 5%, and you can make some street credit on top. So, yeah. Well, I guess I'll go over it since none of you seem to know whether or not I've fucking done it before, and I don't know if I've done it before. So 12 pages, bullshit. Well, I do know that was it this one? So the court ordered already, if a motion to stay discovery is filed by that date, i.e. September 12th, discovery will be stayed on an interim basis pending resolution of that request. If a motion to stay discovery is not filed by that date, they have to file a joint discovery plan by September 19th. So starting off, that is the operative. And your legal questions? All right, nice. All right, so I guess we'll go over all of this fucking bullshit. Oh, this fucking bullshit. Well, long story short, these guys were saying that the motion to dismiss can be adjudicated based on the pleadings. It should be done based on the pleadings, and the court should stay discovery until after the 12B6 motion is resolved. That's what all of this is saying, and that's a very, very good argument, and I don't see how the court isn't going to do that, especially considering that that Wallace filed a motion to stay, and he wanted it stayed for an extended period of time. So he filed this motion to extend time, and he was asking till like December of September 25th or longer. So he's already asked the court to stay it or longer. The LVMPD said, we're like totally okay until the 25th, but we don't want to go past, we're not okay. Or we want his deadline to their motion to strike to be September 15th, and they don't want to go past that. So there's already been a request to stay, and so I don't see why the court won't grant LVMPD's motion to stay motion to stay discovery. All right, so then Wallace opposes it. Chile opposes it because Chile's a fucking retard. And the circuit test for motion to stay discovery. Courts in this district adopted a two-part test to determine whether to stay discovery pending resolution of a dispositive motion. First, the pending motion must be potentially dispositive of the entire case, or at least dispositive on the issue at which discovery is directed. So they win on that. LVMPD wins on that. If LVMPD wins on the they have a motion to strike and a motion to dismiss, I think. Either one of those is potentially dispositive. Second, the court must determine whether the pending dispositive motion can be decided absent discovery. It can be. A 12B6 motion is normally decided without discovery, and the motion to strike is based on things that aren't in the discovery field. So I would posit to you that the court is most likely going to grant it. If the court answers these two questions in the affirmative, a protective order may issue. However, if either prong of this test is not established, discovery proceeds. In applying this two-factor test, the court decides a motion to stay must take a preliminary peek at the merits of the pending dispositive motion to assess whether stay is warranted. B, courts cannot assess the merits. In this case, as defendants' motions to dismiss are not fully briefed, the court cannot assess the merits of the motion. Yeah, it can. It can look at the video, which has been probably entered into or assimilated into the complaint of the arrest, and the court can make some fucking decisions based on that. C, not all claims fail. Despite defendants' continuous misstatements of fact in this case and continuous fanciful legal conclusions, Jesus Christ, like, he's so condescending. Chili's so fucking condescending. He doesn't know a goddamn thing he's talking about, and then he gets all condescending. And like, the court knows that Chili doesn't know what the fuck he's talking about. The court understands that. The court's like, you're pro per, you're not a genius. Your legal conclusions are generally shit. Your pleading is fucking terrible. And you're condescending. It's like, it's this trifecta of bullshittery. Yeah, they've got their little pecking order worked out. The new dog is Kensington. He's getting along pretty well with everybody. Patty kind of doesn't really pay him much mind. Our youngest dog, Siobhan, likes to provoke him into playing, and he's perked up quite a bit. He was not as exercised when we got him, and doing stuff around here and having the other dogs play with him, they've gotten him in better shape, and he's getting a little more spring in his step. So the facts show, and the defendants admit to, detain me without any reasonable articulable suspicion of a crime. They did not admit to that. And see, if they had admitted to it, there would be some sort of a citation there. Using excessive force by pointing a gun at me. They don't admit to using excessive force. So that's also not a correct statement. Never asking me for my identity. They never assert that they asked, only that I refused, which I did not and could not have done if they had never asked. Again, no citation. Arresting me without probable cause, fulfilling the offense from the public. The defendants did not admit that they arrested Wallace without probable cause while I was exercising my First Amendment rights to record police interactions, which is a clearly established right. What is ECF 33? Boop. All right, we got that open, and we're going to go back to the reply, and hold on, I don't want this one. I want the response. Here we go. All right. So excessive force. They agreed that they use excessive force. ECF 33 4 1 to 2. So we're looking at 4 1 to 2. Page 4 1 to 2. Where in here do they agree to excessive force? Survey says nowhere. So that's a fucking lie. Then we got arresting without probable cause, fulfilling offense from the public. 3:19 to 11. Or 11 to 19. What? Hold on a second. 3:11 to 19. This is page 3. I don't know why we... This is page 3. This is page 3, 11 to 19. Fucking Jesus Christ, this guy's fucking terrible. All right. And then, while I was exercising my First Amendment rights. So page 4, 13 to 15. Wallace is a First Amendment officer social movement that involves photographing or filming. They're not admitting that you were exercising. Oh, should this have said. They're not admitting you're exercising your First Amendment right there, buddy. To record police interactions, which is a clearly established right. No page citation on this. So this is what we like to call a bad citation. There is no page number there. Wouldn't it be nice if you put a fucking page number? Just generally speaking, just read this whole opinion somewhere in there. Fuck you, I'm not going to do the work for you. Arresting me for a misdemeanor offense, which they could have simply cited me for, and which their arrest policy says to not arrest for, only to not have any charges brought, resulting in my being arrested simply as a punishment for recording the police, chilling my civil rights. I don't know how what was it? Attempted trespass? Is it like where does he get attempted trespass is something that their policy says not to arrest for? See also this court's own decision in Procare Hospice of Nevada, yada yada. This court, is it really the same fucking court? Let's check it out. Check it out. Work out. Nancy J. Cope, United States Magistrate Judge. All right. So this is and where are we looking? We're looking page 179. Page 179. What am I doing here? Ooh. This isn't it. This is not the case you're looking for. Mm-hmm. Well, let's try it this way then. Damn you. Search the Google. So 340 FRD 174. Maybe if I put it in quotes. Maybe. All right. And where do I get 179? I don't know. 179. Nothing. Well, fuck me. I don't know where 179 is. I don't know. Well, okay. Well, let's think about this logically. If it starts on 174, then 5 pages in is roughly where we would be. So let's look for 5 pages in. All right. We're talking about anti-slap. Okay. So this is talking about staying it. So they're talking about a discovery state provision in a specific Nevada anti-slap law And so this is not applicable because nothing that the defendants have raised is an anti-SLAPP motion. SLAPP is strategic lawsuit against public participation. And that's not applicable to this particular case. Oh, that would be a trick. I mean, I would definitely save that Rottweiler shit if it was the truth. All right. Defendant's video submission of video number 2, blah, 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 shows the gun pointed directly at me. Video also shows the officers asking me for my identification, not my identity. Well, you're like, if they have probable cause to stop you, then under Nevada law, they have the right to ask you for your identification. Identification is proof of one's identity according to every dictionary in the world. The video also shows me providing my identity or my identification under threat of arrest, yet I was still arrested. Moreover, even if some or all of my claims are deficient, the court will assess whether leave to amend should be granted, rendering defendants' motions non-dispositive. Denying a motion to say discovery pending resolution of a motion to dismiss. Okay. The court will assess whether leave to amend should be. So this is a weird argument that I don't understand. I guess he's saying that if the court grants the motion to dismiss, then the court may give him leave to amend, in which case the motion to dismiss wasn't dispositive. I don't think it works that way. But let's look up Singh versus Google, which I'm sure will be entirely on point. Right? I'm sure this will be on point. When was this? This was November 4th, 2016. Shall this tab instead? And we're looking at page dos. That's Spanish for 2. Good cause for saying discovery may exist when the district court is, quote, convinced the plaintiff will be unable to state a claim for relief. Saying discovery when the court is convinced the plaintiff will be unable to state a claim for relief. Under Ninth Circuit law, a party seeking a stay of discovery carries a heavy burden of making a, quote, strong showing, and, quote, why discovery should be denied. Courts in the district have applied a two-pronged test. Yeah. So here's the fucking problem with this, kids, in case you weren't aware of it. The problem is the court already ordered a stay of discovery. The court already ordered a stay of discovery pending the so the court's order was that if someone files a motion to stay discovery, discovery will be stayed pending resolution of the motion to stay discovery. So it's already stayed. And so all the court has to do now is figure out whether or not to keep it stayed. And I think the court's going to keep it stayed. But this doesn't make sense. So I don't know what he's trying to say here, though. I don't know what he's trying to say here. Because remember, we're looking at something along the lines of, moreover, even if some or all of my claims are deficient, the court will assess whether leave to amend should be granted, rendering defendant's motions dispositive. Google seeks a stay of discovery to spare the parties from needless discovery burdens before the legal sufficiency of the First Amendment complaint has been tested, and to spare the court from having to address possible discovery disputes in a case that may never proceed past the motion to dismiss stage. Google also contends that because plaintiff has not alleged that he pursued his claims in Google's claim process as required by the AdWords agreement, he cannot proceed in this action. Therefore, stay is appropriate here. Plaintiff contends, however, that plaintiff has failed to meet it, so there's not even anything dispositive. Court does not find merits for 2 reasons. So we're on page 3, which he did not cite to. First, defendant assumes that even if the court finds that all the claims are deficient for plaintiff's failure to allege that he pursued his claims in Google's claims process as purportedly required, the court would not grant plaintiff leave to amend. Additionally, plaintiff has not yet responded to the motion to dismiss, and thus the court cannot, by a preliminary peek assess the merits of the motion. Well, let me check something real quick. On page 3 or 4, and that's what I want. Here's the motion to extend or shorten time. Number 27. Because, see, the court hasn't even ruled on this motion to extend time to respond to the motion to strike. And he asked for it to be stayed until September 15th. My calendar says it's September 22nd. So that's interesting. It's technically unopposed at this point. It's technically unopposed. So responses were due by 8/31, and responses were filed. And then there is nothing. Fucking weird. Oops, this isn't what I want. Holy Jesus, there's so much. Oh. So, what I think the court will do is I think the court will most likely set a deadline for the motion to strike for the responsive pleadings to those. Is there a 12b6? Is there a 12b6? There's the motion to strike the complaint. Oop, you guys can't see what I'm seeing. Motion to strike the complaint. I thought there is a motion to dismiss. So there's a motion to dismiss and a motion to strike. Hold on a second. I have been summoned. All right, I'm back. So I guess we're waiting for the district judge to rule on the motion to dismiss and the motion to strike. So I don't know. I think the magistrate's probably at this point. My best guess would be the magistrate's probably going to allow the stay, because there's two. There's not just one. There's two dispositive motions. Anyway, I guess we'll take a look at the reply. Yep, they're both potentially dispositive. Yep. And then additional discovery is not necessary. His complaint states sufficient facts for the court to conclude all of his claims fail. In addition, he videotaped the entire encounter. He submitted his videos to the court and requests the court take judicial notice of him. Therefore, no genuine loss of material fact, no genuine issues of material fact exist as to what happened, and no additional discovery is necessary to resolve legal issues in defendant's motions. Wallace doesn't contest this fact. The final requirement is court conduct a preliminary peek of the merits of the motions dismissed, determine the likelihood claims will be dismissed. Wallace argued the defendants admit that they, 1, detained him without reasonable suspicion, 2, used excessive force, 3, arrested him without probable cause for exercising his First Amendment rights, and 4, performed custodial arrest when they could have just cited him. The defendants do not admit any of these facts, and each argument is easily defeated. Lack of reasonable suspicion. Yes, they had reasonable. Well, they arguably had reasonable suspicion. Again, reasonable suspicion is super low bar. Probable cause is a low bar. Reasonable suspicion is a super low bar. Remember Terry versus Ohio, the seminal case. The facts at play were Terry and an associate were standing in the corner. They would one or the other would walk up to a window of a jewelry store and look in, and then walk back to the corner and talk. And this happened multiple times. And then they started going down the street where they met up with another compatriot. Based on those facts, Officer McFadden thought that there's reasonable suspicion that they were casing the place to do an armed robbery. Based on that, he had reasonable suspicion that they would be armed. And so he conducted the pat down. He did the Terry frisk, and he found the firearm on Terry. And so there you go. I don't think anybody's going to get popped for forgery. I think you're just too hopeful that something bad will happen. Did you wash your hands? I just let the dog out. Who let the dog out? So no, I did not wash my hands. I walked over to a doorknob. I opened the door. I whistled for the dog. Siobhan and Kenzie both came out, and so now they're out here somewhere, and I don't know where, but they're out here somewhere. So no, I did not wash my hands. No, I did not. I had to let the dogs out. Once you go dark, then you've hit the mark, I guess. He'll probably get through the process in less than 8 minutes. Okay. Motion to extend Phallus Magna. Nice. It's all fraudulent. We're going to be real about things. Okay. All right. So, yeah, reasonable suspicion, super low bar. It would be next to impossible to for a cop who is at all sentient to be unable to allege facts sufficient to give reasonable suspicion. Excessive force. He claims his excessive force claim will survive dismissal because his video shows an officer pointing a gun at him. This fact is insufficient to state an excessive force claim. The video shows the officer approaching Wallace when he's on the sidewalk. It is undisputed that Wallace was masked, acting suspicious, ignoring the officer's commands to stop, and he had not been searched. The officer, who's several feet away from Wallace, has his firearm out until Wallace stops and complies. The video shows the officer never pointed the gun at Wallace's head. I guess that might be a question of fact. It's hard for me to tell looking at the video. I don't know what it did. It appeared that the gun was pointed vaguely in Wallace's direction. I don't know that that's really like, does it really matter if the gun is pointed at his head? Or, I mean, like, isn't a gun very likely to be fatal if it's pointed at just about any part of your body? I mean, people die from getting shot in the leg, if it severs an artery or something like that, they bleed out quick. I mean, or shock. People die of shock from gunshot wounds all the time. I mean, there's guns are deadly weapons, and they call them deadly weapons because they're deadly, or at least likely to be deadly. So, yeah, I don't know that it's really. I don't know that I think it's kind of a red herring whether or not the gun was pointed at his head or at his chest. I don't know that that's going to really determine anything. Is really what I'm saying. The video shows the officer never pointed the gun at Wallace's head. He altered the weapon the moment Wallace complied, according to the Ninth Circuit. The drawing of a weapon becomes unreasonable when, quote, police officer terrorizes a civilian by brandishing a cocked gun. Like some guns you don't cock. The striker fire ones, like a lot of times you can't even cock the gun. I mean, it's hidden inside the housing. I mean, or the slide. So there's a lot of guns that you can't cock. Like they're not cockable. They're uncockable. I don't know about Popo, but the general rule of firearms is you don't point it remotely in the direction of someone unless you intend to kill them. Right, because they're deadly weapons. Yeah, they're deadly fucking weapons. The video confirms the firearms was never pointed at Wallace's face, and the officer never terrorized Wallace. I think what they're arguing about is like if you come up and like pointing the gun like right in his face, like motherfucker, blah blah blah, then that might be terrorizing him. Just having the gun out is probably not terrorizing them. Although I would be terrified if a cop pulled a gun on me. I don't think that's what the Ninth Circuit was envisioning. No reasonable jury could review the video and find the officer's decision to temporarily draw his firearm until Wallace complied was unreasonable. I would suggest that I didn't think it was unreasonable for the officer to respond in the way he did. Also, Wallace does not argue any clearly established law prohibited the officer's use of the firearm under similar circumstances. Therefore, at a minimum, the officer is entitled to qualified immunity. That's a strong argument. Qualified immunity is a very strong argument, the clearly defined. Most Glocks can't be cocked, and tons of agencies use Glocks. Yeah, they're striker fired. Yeah, it's a real bitch when the cock is drawn up and covered. I know. I like my cock exposed. I mean, your cock doesn't Glock? Well, you should treat it nice. Lack of probable cause to arrest. Wallace argues the officers lacked probable cause to arrest him because they arrested him for exercising his First Amendment rights. He wasn't arrested for exercising his First Amendment rights. He was arrested for attempted trespass, and probable cause existed for his arrest. Probable cause requires only a probability or a substantial chance of criminal activity, not an actual showing of such activity, and is not a high bar. In Nevada, probable cause can be based on slight evidence. The officers arrested Wallace for attempted trespass. Nevada Rev Stat makes it a misdemeanor for any person under circumstances not amounting to burglary to go upon the land or into any building of another with intent to vex or annoy the owner or occupant thereof, or to commit any unlawful act. Here, Wallace's video confirms he went onto LVMPD property to vex and annoy its occupants and to provoke a police encounter. Undeniably, clearly, probable cause exists. Obviously he would. He definitely would. The zombie virus allows people to do things that they could not do as living human beings. So yes, he would be able to walk, clearly. Oh, is that clearly the drinking word now? Clearly it's a drinking word. Clearly it's a drinking word. So I will have some coffee. I wonder if Coded's going to believe that me drinking coffee is going to make me piss all over the place and have to install more fish tanks to cover the smell. Although I am planning on getting more fish tanks. It's kind of irritating. PetSmart raised the price of fish tanks by a lot, and then they have them 50% off. Like, don't fuck around, dude. Just like, if that's the price you're going to sell them for, then just sell them for that price. Don't piss on my back and tell me it's raining. Also, the video and complaint established that Wallace refused to identify himself for over 3 minutes after being asked to do so. It's obstruction under Nevada law to impede and or prolong an investigation. Nevada district courts have held that an individual is obstructing when the individual is given several opportunities to comply with defendant's orders but failed to do so. Wallace admits in his video establishes that he impeded the officer's investigation by failing to identify himself for over 3 minutes after being asked to do so. And then Hibble says that he has to disclose his name during a Terry stop. That's Nevada law. Check with a local attorney. Therefore, at a minimum, probable cause. Did Chili gain weight? I don't follow him, but wasn't he going to do some sort of a diet? Wasn't he doing some like he'd gained a bunch of weight so he could do some diet to like a intermittent fasting diet or some weird shit where he was fasting diet. Yeah. So I mean, if he is gaining weight, that's sad. I hate to see him I hate to see someone who's on a diet gain weight. What size? Oh, tank size. I was thinking about picking up a couple more 29s. They're a really good size tank. And I have to break down my pond, my 300 gallon pond. It's a stock tank pond. I have to break that down because it's starting to get cool out. And I've got mollies in it, and I've got some bristle nose plecos in it that won't survive the cold. I've got a weather loach, a dojo loach in there. I think I could leave him in there. And I've got some rosy red minnows, some fathead minnows that'll probably survive the cold too. Fasting lowers your metabolism and makes you retain fat. I mean, sure. I'm not a dietitian. Well, don't ash on your mouse pad. Intermittent fatting, nice. Easy solution for chili not to gain weight. Easy solution for chili is to not gain weight in the first place. Well, metabolism slow down when you hit. He's about 50, right? Metabolism slow down around then. And no, I don't keep sharks with freaking laser memes. Therefore, at a minimum, obstruction. They could have arrested him for obstruction. In fact, they didn't arrest him for obstruction. It's irrelevant. Probable cause supports an arrest so long as the officers had probable cause to arrest for any criminal offense. Finally, the officers learned that Wallace had a warrant from another jurisdiction and could have arrested him on that basis. Interesting. So they had ample probable cause. Custodial arrest for citation. Wallace argues that issue exists because the officers performed a custodial arrest. Take that off. When they could have just cited him for a misdemeanor, this argument is irrelevant. Supreme Court stated that if an officer has probable cause to believe that an individual has committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender. Therefore, as a matter of law, the officers did not violate his constitutional rights. Seems like a pretty reasonable document. All right. And then we have a motion to strike. A motion to strike. All right. So this is a chilly motion to strike because he's a fucking idiot. A reply brief may be filed and served within 7 days from the date of service or response. Reply brief must only address arguments made in the response. Here, everything raised in defense replies unrelated to my opposition to the motion. Was it, though? Was it? But was it? Save, open, back. Save. All right. So here's his opposition. All right. So we have the two-part test. It has to be dispositive. They address that. And then the court must determine whether the pending dispositive motion can be decided absent discovery. Okay. The court cannot assess the merits. In this case, defendant's motion is dismissed. All right. So I don't know if I think they were addressing that. They're addressing whether or not the court can assess the merits. And then he says not all claims fail. So he raises the reasonable suspicion. They address that. Excessive force. They address that. Asking to identify. They address that. Arresting without probable cause. They address that. And misdemeanor offense. They address that. So everything that they've raised, everything, literally everything that they brought up was raised. So you have A, potentially dispositive. B, additional discovery is not necessary. The final requirement is for the court to do the preliminary peek. These are the four things that Wallace argued. So 1, detained without or reasonable suspicion. That's there. 2, used excessive force. That's there. 3, arrest without probable cause. That's there. And 4, performed custodial arrest when they could have just detained him, is there. So literally everything. Literally everything. Oh, you didn't see any of that. Well, you could just go over it again. But anyway, there's potentially dispositive, additional discovery not necessary. These are the 4 factors that Wallace raised: lack of reasonable suspicion, excessive force, lack of probable cause, and custodial arrest for a citation. That's what Wallace raised, and that's what they argued. So this is going to be fucking stupid. I can already tell you. Motion to strike or to file a certify. Jesus fucking Christ. Improper to raise new facts and different legal arguments. It's not he was replying. He addressed the arguments made in the response. So potentially dispositive. Well, defendants misstate the facts. I have not yet responded to the second. What? Oh. So defendants argue that both of defendants' motions to dismiss request dismissal of all claims. So the motion to strike is to strike the whole fucking pleading. The motion to dismiss is to dismiss every cause of action. If Wallace contests that fact, it would be stupid, because if he for some reason does not contest any one of those points, if he doesn't contest the entire motion to strike, if he doesn't contest the motions to dismiss every single cause of action, whatever he doesn't contest will then be granted because it's unopposed. Oh, that's the stupidest logic I've ever seen. Additional discovery is necessary. Is this the Nope defense? Well, so they're arguing that the video shows otherwise. And again, I don't think it's just positive. Lack of reasonable suspicion. It's false and not supported by the record. Neither the video nor my complaint show a mask or the donning of a mask after I arrived at the substation. Somebody said he was wearing a mask. The complaint said you were wearing a mask. The complaint said you were wearing a mask. The first amended, was it the first amended complaint? Here's the complaint. Was there a first amended? One of them talked about a mask. So there is no first amended complaint. All right, let's go. Let's go. Let's go. No, it's not searchable. Damn it. All right. So right there, 33. Soon after, one of the officers accused plaintiff of, quote, wearing a mask, to which plaintiff answered, for COVID. He admitted to wearing a mask. You fucking idiot. Like, why do you have to waste everybody's time, Chili? Why do you have to waste everybody's fucking time? You think that people aren't going to understand this shit and respond to it? Fucking gay and lame. Gay and lame. All right, excessive force, no probable cause. I don't fucking care. I just don't care. Defendants failed to defend my complaints under state law, as well as my complaints related to retaliatory arrest. You didn't raise those in your opposition, you dipshit. They don't have to. You didn't raise them in your opposition. Fuck. Plaintiff's objection motion to district. Oh boy. So now he's asking the court to clarify its order from September 15th. Alternatively, I object to it. Pursuant to local rule in the U.S. Code, I object to the magistrate judge's order and requested a de novo review of the record. I don't believe that you're entitled to that. I've been over this before, and I don't believe you're entitled to that. District of Nevada local rules. District of Nevada local rules. Local rule IB 3-228. 228. Give it to me. Okay. Don't give it to me. What am I doing wrong here? Local rule IB 3-228. Copy. Bloom. I think he means 3-2. I think he means 3-2. Whoops. I think this is what he means. Why the fuck is he talking about 3-228? There is no 3-228. So, oh no. So this again, this is matters that may not be finally determined by a magistrate judge. Magistrate judges can finally determine discovery issues and motions to stay discovery. That is something that a magistrate judge can issue a final determination. So when if there's something that's dispositive, like on a motion to dismiss, oftentimes the district court judge will have the magistrate hear like the arguments and things like that, and then the magistrate judge will issue findings and recommendation, and then the district court will review the findings and recommendation and then either adopt it or not. And in this particular, for this, what this rule is talking about is if the magistrate judge makes findings and recommendations based on that oral argument, and what you could do is you could object to it and get a de novo review. And that's what it's talking about. But unfortunately for him, a district court may consider any pretrial matter referred to a district court judge under local rule 1 IB 1.3. That's the rule that allows the magistrate to make final decisions on things like discovery motions when it's been shown the magistrate judge is clearly erroneous or contrary to law. So that's what Chile or Wallace would have to show, and that's going to be a problem for him because it's not that order was not clearly erroneous or contrary to law because it was a sua sponte order. It wasn't based on argument, and the magistrate judge has the authority to make that kind of an order. So that's pretty stupid. It's based on memorandum of authority, blah, blah, blah. For motion to stay discovery is filed by that date. Discovery will be stayed on an interim basis pending resolution of that request. I interpreted this to mean that the magistrate judge has incorrectly interpreted the law that a motion to stay takes effect while the motion is pending. No, the magistrate judge issued an order that the discovery would be stayed pending resolution of a motion to stay discovery. It's an order. It's not. The court isn't interpreting a law. The court is making an order, and the court has the authority to make that order. Defendants in their refusal to participate in a Rule 26F conference have said they have interpreted to mean the magistrate judge made an order. Yeah, they made an order. A motion to say does not say anything until it's ruled on in the affirmative. There's already a fucking order that says if you file a motion, discovery is stayed until that motion is resolved. That's the order. Ugh, fucking idiot. Fucking idiot. So he's going to lose on that. All right, what else do we have? Or is that it? Oh, thank fucking Christ, that's it. Thank Christ, that is it. All right. Do I want to go over all this nonsense? I don't know. I don't know. Oh, God, you guys are talkative. Could be out enjoying some hookers and blow, yet here we are. Well, here we are. Indeed, says Singapore Sling. Brandon says, clearly. JJ Thomas says, someone is clearly late. How could I be late? How could I be late? I arrived exactly when I intended to arrive. Just because you fools jumped in before I was live doesn't make me late. Jeff says, it's patently true. We are here. JD Tom says, Murr must be putting the cocks to bed in your mom. Juan Galt says, I believe that involves stroking them because Juan is a master debater. Having shown up the sovereign citizens multiple times, he has honed his master debating skills. Israel D says, hey, sexy. Hey, back at ya. Tom Peter says, Murby Furby. Furries are fucking gross. So, no. Michelle says, hi, Merb. Jeff says, master debater, expert at debating himself. Merb has multiple cocks, says John Hanzo. AU, thumbs up. Arrowslinger, my AI is here by special appearance only. Barely Legal Brief says, can already tell the Merb is not tilted today. Wasn't tilted then either. I was animated. There's a difference. Learn it. Live it, learn it, love it. Walter TX says, hello, Merb, and everyone listening and driving home. Drive safe. Gene Hunsinger says, picture of an asshat. Well, thank you. Michelle says, so glad you're covering this. You're welcome, Michelle. Linda Borham says, hey, Merb. Hey, back at ya. Do you, Borham? Arrow Singer says, oh, sorry. Hi, Merb. Well, oh, sorry. Hi, back at ya. Very Legal Brief says, call Merb is my favorite Merb. Well, sometimes you get a little call Merb. Sometimes you get a little animated Merb. Sometimes you get a mix. Will Vomit says, woohoo! That's the song, by the way. Javer says, happy equinox in precisely 6 hours. Well, happy equinox back at you. Jeepster says, and now deep thoughts from Chili Decastro. I prefer them from Jack Handy myself. Jackson68 says, filming in quotes. John Clark says his hair is really thinning on his forehead. Logan Sandman says, I'm sorry I'm late. What are we talking about now? Never mind. It's just chilly. Alan Killian says, hello, Merb. Watch out for those mosquitoes. I am well sprayed. Thank you. Little spade, too. Walter TX says, hiya, John Clark. John Clark says, hey, Walter. Jackson68 says he tried the protest excuse at the Ironton City Hall. I know. It didn't work out for him then. It won't work out for him now. Tom says, please make this interesting, as most of this moron's new motions seem to get more boring every time we get a new one. I know. That's why I've been reluctant to cover them. They're all shit. They're literally all shit. I mean, there have been relatively few times, where he has stumbled on something that has merit, but not lately. Logan says, John Clark. Nathan says, Murd, he doesn't have the brain cells to understand that. He's not stupid. He's just not open to education. He is Dunning-Kruger. He thinks he knows more than me. And okay. I mean, how well is it working out for you there, bud? GMK says, what form of protest is this black empty screen? Why does it have to be black? Why do you have to bring race into it, GMK? Logan Sandman says, John. Will says, so you have to state to the camera that you are protesting the police. Well, that's his operating theory, and he's sticking to it. It's a pretty dumb theory, but it's his. John Clark says, yep. Logan says, I'm really loving laughing at. There's something about Mary hairdo. Freak says, And back at you. Will Vomit says, I want all the magic words. The magic words are show Bob. Walter TX says, hiya, Logan. Good to see ya. John Clark says, LMAO, Logan. Logan Sandman says, Walter. Adam Killian says, hello, John. Will Vomit says, I plead the fifth while in the stand is magic words as long as I shut the fuck up. Anytime you plead the fifth, shut the fuck up after you plead the fifth. Vixter says, evening bourbon chat. Happy Friday. Happy Friday back at you. John Clark says, hey, Alan. Page says, abracadabra, show Bob. John Clark says, Alan. JJ Thomas says, Chili's gone from a 4-head to a 5-head. Well, that receding hairline is a bitch. Walter TX says, hi, Vixter. Will Vomit says, I wouldn't want Chili anywhere near my constitutional rights. I agree. Freak says, Page. Page says, freaks, show Bob. Will Vomit says, Page, thank you for magic words. Logan Sandman says, fuck Nivens. I want to hear more about Tesh lines and Bette Midler versus Ford. Let's not forget about Terry. Page says, anytime, Will Vomit, show Bob's. Vixter says, hey, Walter, Tex, good to see ya. Freak says, doggy head shake. Walter TX says, yeah, Tesh lines is the most important case of all. Don't you remember the review that Chili did on the justice that was it Mississippi or something like that? Mississippi justice. There was like people would quake at the sound of his name in court or something dumb shit like that. John Clark says that was Chili's brain, not the dog. Freak says lol. Freak says my bad. Walter says free Charlie. John Clark says, lol. John Clark says, Walter, we all know Charlie is with Becca's friend. Logan Sandman says, Merb, you know when a dog audibly scratches his ear, he's ignoring you. That's something that I've just learned. Walter says, dang it, that's right, John Clark. John Clark says, lol. Logan Sandman says, ACAB, 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 and Charlie wasn't arrested. John Clark says, F12. Walter Clark says, Charlie's a good boy. Jay Ver says, is this in Vegas? If so, the police take jaywalking pretty seriously there. Going to be tough to claim it's retaliatory. There was no jaywalking arrest, so I don't know what Chili's going on about. Chili's fucking retarded. Logan Sandman says he's not with Becca or anyone in her family. GMK says, Ahab, 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 Captain, my captain. That was a Moby Dick joke for those of you who aren't aware. Walter TX says, no, he's not as far as I know. Javer says, ah, yes, there we go. Logan Sandman says, at GMK, have you met the whale? GMK says, I made love to it, and then I died. Will Vomit would be impressed. Logan Sandman says, GMK, so you're a mermaid. I didn't know you were that cute. GMK says, I'm okay, good enough to seduce a whale. Well, you know, at least you're not overly vain. Logan Sandman says, GMK, so are you saying you like, quote, fat dudes, end quote? We can talk. Logan is always about getting his dick wet. Yamaha Biker says, all I have to say in regards to Maria, when you do the same thing over and over expecting a different result, that is a definition of insanity. Or doggedness, determination, stick-to-itiveness. Logan Sandman says at Yamaha Biker, and you're liking Yamahas? Isn't that insanity? Some of the older Yamahas are pretty nice. Yamaha Biker says, nope, I can take a Harley V-Rod off the line any day of the week. So, Tread says, I'm late, but thank goodness for VHS. I wouldn't be able to appreciate Burb's work. Are you recording this on VHS? I mean, that's pretty interesting technology choice. Logan Sandman says that Yamaha Biker, don't get me wrong, Yamaha's forks didn't fold up in my head as often as Suzuki's did. Despite the bike, if you didn't break it, you weren't riding it hard enough. Yamaha Biker says that. Logan Sandman, laughing, crying. Matto says, coffee is for the weak. Well, I'm weak then. Chaos Warden says, good defense lawyers will say they good the best they can, but never make a promise that you will get off from the Chargers. Well, I'm not a foosball fan, so I don't know about the Chargers or what it takes to get them off, but maybe. I mean, go team. Logan Sandman says, but my attorney told me to shut the fuck up. He was wrong, and I'm in prison, fucking dick. Well, you have excellent internet for being in prison. Chaos Warden says, fuck, that spelling was awful. Sorry. You should be sorry. Yamaha Biker says that Chaos Warden happens. Chaos Warden says X. Logan Sandman says, did Merb just say chucklehead? Woohoo, we're going old school. Alpha Fox Adam says, gotta love comparators. The Unforgiven Yuri says, Merb in his backyard just chilling like SC Villain. I don't know who SC Villain is. Logan Sandman says, Jerry, I'm still waiting to see the cock. You horny old bastard. The Unforgiven Yuri says, at Logan, just let the cock come naturally, Logan. Don't force it. Force it into your pile. Logan Sandman says, at Unforgiven Yuri, that's what she said. GMK says, he might win based on the demerits. The demerits. Nice. The Unforgiven Yuri says, at Logan, aren't we talking about foul? Charles Wolf says, Cholita's makeup looks a lot more femme nowadays. Yeah. The Unforgiven Yuri says, GMK, is that a Boy Scout thing? Because I think Logan has that badge. Logan says that Yuri, you know it's almost Thanksgiving, so yes, we are. Logan Sandman says, I've got my barbecue and merit badge. Unforgiven Yuri says that Logan, gobble, gobble, said the Kimmy, I mean turkey. Logan Sandman says, at least Kimmy. I don't know what you guys are talking about. Alpha Fox Adam says, comparators, similarly situated individuals. Did a whole appellate advocacy class argument / final brief on them. My bad. Logan Sandman says, fuck YouTube, and there's shit inside chat. At least Kimmy gets delivered with wheels. I don't know what that means, but okay. Hello, puppy. Orange Cone says, hi, Logan. Logan says, cones. The Unforgiven Yuri says, the other day I had a Freudian slip. I wanted to say to my wife, pass the butter, but instead I said, you bitch, you ruined my life. Logan says, apparently Diet Klondike bars show up in MRIs. Interesting. Orange Cone says, what would you do for a Klondike bar? Some people would do, says Unforgiven Yuri, some people would do a lime, apparently, for a Klondike. Somehow this is a category on the hub. Orange Coast says, lying isn't a mistake. Say it ain't so. Alpha Fox Adam says, it's the biggest word I know, seeing as how I'm a poor hillbilly. Logan says, it's spelled pillbilly. Candy Archibald says, say it ain't so. He would lie. The Unforgiven Yuri says, duty. Wait, did I spell that wrong? Alpha Fox Adam says, out Logan Sandman, hey now, I'm not from Georgia. Oops, I didn't show that. Maddie says, duty. The Unforgiven Yuri says, Matt, thank God you are here to correct my crapulence. Alpha Fox Adam says, lol, and who are these experts? Logan Sandman says, whoo, it's good to know, Alpha Fox Adam. I thought I might have been a grand jury indicted capital murderer who is currently facing 5 felony charges. Are we talking about a frauditor wrangler? Whatever one of those frauditor fucksticks are. Paul Berry says, original complaint filed April 13, 2022. Whew! This fucker's been sticking around for a while. That was the Chili versus Ironton, right? Chili versus Wagner. Fuck that dude. Alpha Fox Adam says, Logan Sandman, I do not have a Purple Heart. I also don't have Purple Heart. Oh, but if you want to donate to a real veterans charity, it's Mission 22. Donate directly to them. Don't give your money to anybody else. Biff Thunder Muffin says, expert is an X. An X is a has-been. And a spurt is a little pfft that is over in a second. Logan Yuri, or Unforgiven Yuri says, Logan, come on, man. You know them grand juries. They are all about just wanting to indict poor pill-popping vets of capital murder all willy-nilly. Well, there is, I don't want to defend fraud at fuckwit, but Private Kaiser, I don't want to defend him, but there is a saying that you can indict a ham sandwich. It's not hard to show probable cause. However, they took it seriously enough that they dismissed the case without prejudice to give them time to make sure they have enough evidence to get a conviction. So there you go. I'm petting a dog, by the way, and he keeps lowering his head as I'm scratching his ears, so I have to lean forward to stay with his ears. Is Chili's forensic expert named Matt Decastro? I don't know. Nor do you. Orange Cones asks, is chili synonymous with failure to show cause? I don't know. I think it's synonymous with failure to produce a good pleading. Alan Killian says Zane. Logan Salmon says, I apologize to Merban's chat. I'm normally pretty chill, but the motherfuckingly asshole who flipped my switch has no idea how many other people are looking at him. Sucks to be him. Well, I don't know if Fraud at Fuckwit is going to... there's only so much that can happen to him. I'm not going to bet that he's going to get charged with stolen valor. I'm just not going to bet that any federal agency is going to look at him, or any state agency is really going to spend the time to find him. It could happen, but I just doubt it. I just doubt it. The amount of money he took is probably minimal, and he can make arguments. I don't like the guy, and his audience is probably going to stick around. They are sticking around. He's still like over 3,500 subs, so he's still getting people participating. So I just don't think it's going to be as disastrous for him. There have been so many people who've been just like completely fucking called out on YouTube, and a lot of them just stick around and stay around. Like Earl, after he got fucking caught out being a chomo, he stuck around. He was still producing content. People were still following him. So, and despite what Josh might think, stolen valor doesn't have the same kind of ring to it as chomo. Getting charged with raping your own daughter, sexually assaulting your own daughter. That has a lot more visceral reaction to it for most people. Oh, Yuri says you got to wonder if Jizz Mopper can be considered forensic expert. Logan says, no, Merb, it's fraudit Wrangler shit. Yuri says, Logan Salmon, isn't it more of a buttonless of switch, right? Logan says, that's okay, Merb. I already flossed today. Thank you, though. Scott Amo says, you too, Merb? Small world. Yuri says, Merb, oh shit, nickname brothers. What a coincidence. Yuri says, what? Really? Dang, I knew I liked you for a reason. Fox Adam says, dick name. Matto says, you ruined bunt cake. Unforgiven Yuri says, bunt. Well, I'm Mexican, so expect a nightcap no matter what the shape or size. GMK says, courts usually operate in a courthouse, a limited or non-public forum. I would expect that a courthouse is a non-public forum 99.9% of the time. Chaos Warden says, honestly, what is Chile even trying to prove at this point? I don't know. Logan says, no, it's a switch, Sherry. The buttons are what make me giggle. Yuri says at GMK, but are we ever going to see the return of the dollar menu? Probably not, no. JJ Thomas says, if Chile is denied, speaking of that, like I always, when I was a kid, my parents always tell me, I used to buy candy bars for a nickel. I'd never really, but now I'm like, my God, I remember buying gas when it was like 87 cents a gallon. Those times have passed, those times have passed. And we become the old folks, and we start telling the kids the stories about the good old days. And then they're going to tell their kids about the good old days. And, the days that we think everything is overpriced and expensive and stupid are going to be the days where they think everything was reasonably priced, yada, yada. J.J. Thomas says, if Chile is denied his motion to file a second amended complaint, it's clearly because of a corrupt judge in court. Maybe. That's maybe what he'll argue. I don't know. Yuri says, at Logan Salmon, you're starting to be late in the chat or trying to take coded friends thing. Mm-hmm. Don't be stealing, says Mandy777. Orange Cones asks, Merb, are facts really necessary for the court? Well, some are, but he was arguing facts when he should have been arguing law, is really the problem. GMK says, at Yuri, no, the dollar menu has been sucked up by a vacuum, never to return. Logan Salmon says, fuck you, Yuri. I'm 45 minutes behind. Orange Cone says, this is clearly primo BS. Yuri says at GMK, crying. It's not fair. I should be able to clog my arteries with reasonably priced crappy food. Becken Hall says, what kind of operation is this? Probably a pretty shit one. Yuri says he probably dropped Nutella on that page. Logan Sandman says that orange cones without a condom, you're going down the rabbit hole of parenthood. Not my circus, not my monkey. Michelle says, according to Chili, just uttering words make it so. I guess that's what's happening in this filing. GMK says, at Yuri, lol, sadly, life's not fair. For example, I'm unfairly suffering through Merb's legal seminar without getting any continuing education credit. Well, that sucks. J. Thomas asks, what is he appealing? And I've already answered that. He's appealing the younger abstention doctrine. Yuri says, GMK, good thing for you. I got a shit ton of street credit. I could co-sign for you, but I can't go lower than 2.3% on my street credit. GMK says, no, he's appealing the older extension doctrine. Logan Sandman says, I spent my entire adult life picking up dog shit and you're me legal questions. Michelle says, that's funny. The Unforgiven Yuri says, everyone wins. Good shit, Merb. Logan says, fuck me, I can't even spell. Orange Code says, 12 pages of bullshit. Let me get my hip waders. GMK says, at Yuri, I appreciate the below prime rate. Yuri says, neither can I. Logan Sandman, find a second language. People will forgive you for all the typos. Logan Sandman says, at Yuri, ton is British. I thought you were born in East LA. Scott Amo says, the newest filing starts motion to strike defendants. Get away from me. Yuri says at GMK, that's only for you. Don't be going around telling little Kiki or any of my cousins those fuckers are to find out when they owe dues. Orange Coast asks, can Ohio ban chili when all this is done? Lol. No. You have a right to travel. Yuri says, shut up, Logan. Quacks too much says, remember, police can, quote, lie probable cause into existence, end quote, which is another reason to record the police. I mean, technically anyone can lie. The police can lie to you, but on the stand, they're not allowed to lie. They may lie, but they're not allowed to lie. And they would be subject to perjury just like anybody else, potentially, if they did lie on the stand. So, when you say they can lie, technically they're able to, yes, but legally they're not allowed to on the stand. Anything for Selena says, they took our jobs. I don't know why we're saying that, but okay. Logan says that Yuri, I speak really good hooker Spanglish, and German. Then there's bar girl Korean. Well, we know why you have to get so many shots. Orange Cones asks, are all the dogs getting along? Hope so, they are. Logan says, I'm still waiting for Fabio to take over this live stream. We all know he's a huge cock. You know, they haven't been all crowy lately. I think it's the change of weather. Days are getting shorter. They're retiring earlier. I'm going to have to close up the coops when I'm done with the stream. Yuri says, I've seen bigger. Quacks too much, says, quote, probable cause, end quote. J.D. Thomas says, despite being illegally arrested 3 times in 1 month, Floyd is managing to keep up with his filings. He is totally writing himself. Indeed. Sandman says that, Yuri, so you're one of my subscribers on OnlyFans. Thanks, baby. J.D. Thomas says, I thought Ohio was the state Chili was running for governor in. Well, I don't think that's going well for him. Yuri says that, Logan, you gave me the money to subscribe. Remember, you said it's to get the ball rolling or something. Is that like Gia priming the pump for Welsh Snooze Network? For Dildo Dan? Logan says, ha ha, he said ball rolling. Quacks too much says, it seems CJ Grisham is now an attorney. Is it true? I believe he has a probational license or a provisional license. I think if he fucks up, then he's going to lose it. But yeah, he can practice law right now. Congrats to him. He's still a fuckwit. Candy Archibald says, fuggin' lol. JG Thomas says, at Quacks too much, that's what they say. Orange Cone says, my Farlowella daddy is tending 46 eggs. That's congratulations. I hope you have someone who's willing to buy all those baby Farlowella. Logan Salmon says, hey, Jerry, just bring charcoal. I've got the meat. Nice. You've got the meat. Big boy. Big boy. Yuri says, let's just take a minute to understand Chili thinks we live in the movie Judge Dredd's Sylvester Stallone version. And chili is the law. Michelle says, this actually sounds like Floyd wrote this. Logan Salmon says, at Yuri, I am the law. The Unforgiven Yuri says, Logan, why would I need to bring coal to a Arby's? I don't know. Orange Cone says, I think my Rottweiler could shit better pleadings. I'm an hour behind. I'll catch up. Unforgiven Yuri says, at Cones, your Rottweiler definitely gets better odds in Vegas. JJ Thomas says, at Yuri, Chili's always right. It's everyone else that's wrong. We know this because he's a 20-year constitutional law scholar. Isn't he a 21-year constitutional law scholar by now? Logan Salmon says, seriously, Jerry, I'm not taking you to Arby's. I'm doing this shit in my backyard. Doing it in your backyard, huh? Logan Salmon says, at Orange Cones, I'm pretty sure your Rottweiler can shit things bigger than chili. Yuri says that Logan Sandman, for real, okay, but number one, can I bring my cat? And number two, you got my Uber because you may be close, but you're California close. You know what I mean. If we're having a barbecue, you need to tell me where. Logan Sandman says, bring your cat. Jerry, I had to take a second to think about that, but fuck it. That'll be fun. Don't worry, I have beer and weed. Fuck yeah. Iowa Hank says, where does Floyd get that pointing a gun at him in the circumstances is worth a shekel for him? If he's being terrorized, like if the cop is pointing the gun at his head, like in his face, then that would be terrorizing him with the firearm. That might be excessive force. Yuri says, fuck, I'm down, Logan. I hope you are being for real. Do I get you on Discord? I do, don't I? Javer says, wait, did Decastro, who arguably filed slap lawsuits, claim he was being slapped? I don't know why he was quoting that case that dealt with slap. I don't know. Logan says, put the beer down, Jerry. No, Jerry, you keep drinking. You're cool. Orange Cone says, hashtag PLF. Poor little feller. Logan Salmon says, and no, I'm not paying for your Uber, Jerry. Don't forget, bring the charcoal. And don't bring the matchlight charcoal. Bring real charcoal that you have to get going on its own. Because that matchlight stuff, it has a slight flavor to it that you could taste. I mean, you could taste the accelerant. I don't like it. JJ Thomas says, bless his heart. The Unforgiven Year says, maybe Merb, you don't understand, because chili gas reached a level of law scholar that not even you could reach. Of you strike him down with lightsaber. No, wait, that's Star Wars. My bad. Logan says, Chili gets really pissed off when a cop taller than him reaches. Yuri says, Logan, damn it, way to fish pull someone, but for real. How many miles are you from my location, given you have a rough idea? Orange Code says, wonder where Chili's going in December. Another Colombian trip for trippy powder? The Unforgiven Year says, damn it, typos in leaving. I don't care. Fuck it all. Yuri says, damn it. Captain Clown says, nothing else matters but music. Logan Sandman says, at Yuri, about 60 miles, go west on the 10 and take a right on the 405. Yuri says, Captain Clown, all your words you don't just say. Orange Cones asks if I went dark. Yuri says, Sandman, fuck that Uber ride. I'll get a car. When I get a car again, I'll go chill for real, for real. Logan says, at Orange Cones, how much you want to bet some broke dick retired Gandalf looking like motherfucker is going to drop a dime when Chili comes back to the U.S.? I don't know what that means. Brandon says, did you wash your hands? Unforgiven Yuri says, Merb had to talk to his wife. Thomas says, once you go dark, I forget the rest. Sandman says, Orange Cones, he will probably get through the process in less than 8 minutes. GMK says, motion to extend Phallus Magna. Rodent, no last name, says, Merb, question if Chili files with Floyd's signature on the document, could that be forgery? Yuri asks, Rodent, it's all fraudulent. We are going to be real about things. Bandon says, okay. Yuri says, damn typos are plaguing me. Fox Adam says, rolls 20-sided die. A noble wizard is summoned. Captain Clown says, no, it doesn't. Logan says, eggshells plague me, Jerry. But they are crunchy. All right. Javer says, I don't know about Popo, but the general rule of firearms is don't point it remotely in the direction of someone unless you intend to kill them. Yuri says, Logan, please tell me that wasn't what you meant when you said I walk on eggshells all day. Javer says, again, it doesn't matter if it's loaded, unloaded, charged, or safe. You don't point a firearm at someone unless you intend to kill them. Orange Cone says, my Glock don't cock. Logan says, if you added 2 more O's, Javers, I would have guessed you're going through diaper training. Jasper says most clocks can't be cocked, and tons of agencies use clocks. Scott Amos says, yeah, it's a real bitch when a cock is drawn and covered. Alpha Fox Adam says, my cock don't glock. Yuri says, Javers, dang, no one can have fun anymore. Sheesh, we still hold out guns sideways in one hand. Logan says that Yuri, really? Since when have you ever gotten the impression I walk on eggshells? I was talking about breakfast. Javer says that Yuri, I mean, you can, but it ruins your grouping. Scott Rickhoff says, sir, if FDR came back as a zombie, could he walk again? Captain Clown says, unless there is a loaded chamber indicator, you can't clearly tell if a firearm is cocked. Unforgiven Yuri says, Javers, no wonder I can't get no play from the ladies. Logan says, clearly, drink. Scott Richthoff says, Chili looks like he's looks like he's a lot of weight. Captain Clown says, loaded. Logan Sandman says, I'm drinking bong water. Don't tell Fraud Wrangler. That's terrible, dude. Don't drink bong water. Street Dominator says, I'm getting drunk. Captain Clown says there's clear evidence that he could crawl. Scott Richthoff says, Chili has certainly gained some weight this past year. Javer says, yeah, fasting. Street Dominator says, fasting. J.D. Thomas says, Wallace has been trying to get arrested for exercising his 1A rights when he first claimed to be a 1A auditor. Orange Cones asks, what size, Burb? Tank size. Get your mind out of the gutter. Javer says, fasting lowers your metabolism and makes you retain fat. Yuri says, Logan, I'm smoking a blunt and I keep ashing it on my mouse pad. Fuck. Alpha Fox Adam says, intermittent fatting. Scott Amos says, easy solution for Chili is to not gain weight in the first place. Yuri says, Alpha Fox Adam, oh, the Kimmy Wrangler diet. That's bad. Captain Clown says, no sharks in your with freaking laser nemes. Logan Sandman says, Jerry, don't get me started on my anime hottie who has awesome boobs mouse pad. Gross. Drunk Rob TBD says you have 30 more live viewers than Chili. Fun fact. Well, that's terrible. Captain Clown says, fat fingered that. Yuri says, Captain Clown, you know my pain. Yuri says, and my girlfriend's. Logan says, so when I say my ex-wife was jealous of my mouse pad, I'm not making it up. Captain Clown says, do I? Yuri says, Logan, enough about your lady pads, please. Yuri says, at Captain Clown, fat fingers, laughing, crying. Logan says, so you won't be asking for any pictures? Whew. Guess Warren asked Murbies, when do you think the judges will address Floyd using e-filing without permission? That's on the motion to strike. So the motion to strike is based on somebody filing for Floyd. That's what it's based on. So in part. So that's when it will be addressed. Captain Clowns laughs at the Unforgiven. Yuri says at Logan, you got pictures. Oh, wait, let's not get hasty now. Logan says, I just got a notification on a comment I left over a year ago. I was talking about pens. Pen is mightier than the sword. Get it? Pen is mightier than the sword. Scott Amos says, wait until you see a citations for the excessive force claims. I guess I didn't get into that. J.J. Thomas says, must be good. Logan Sandman says, citations. Come on, carbonless paper. If it's on real paper, you're in trouble. David Price says, next line, he admits to wearing a mask. Michelle says he admitted to it, I believe. Fox Adams says, Merb, was that you that spoke in Sacramento City Council meeting pretending to be a woman named Judy Tester? No, I don't. I have not ever spoken at a Sacramento City Council meeting or any City Council meeting. J.J. Thomas says it was mentioned for sure. Logan Sandman says, when my girlfriend wears a mask, she looks like Spider-Woman. Don't kink shame. Nancy Nathaniel says, Merb, you're a fascinating man. Captain Clown says, you can't expect Joe Sloyd to remember every lie told, can you? Chili, Cass Warden says, Chili thinks the courts are stupid. Yes, but he's wrong. He's stupid. Logan Sandman says, and if I could swing it, Wonder Woman is going to join us. Nice. J.J. Thomas says, this is clearly a Wallace filing, not Chili. Orange Cohen says, do you say clearly in court? If do you think of us when you say it? Lol. I try not to use that word. I try not to use clearly or patently or anything like that. Robert McGavany says he said he wore a mask the day of the arrest to avoid COVID when he was outside and then shows up with Chili, maskless, and goes inside. Yeah, I mean, yeah, he's not consistent. JJ Thomas says that's because you're only at risk of COVID around the police outside. Captain Khan says, how can you expect a constitutional law scholar to put together a sound legal argument if he clearly did pay attention to the first mistakes pointed out in the opposition's response? I don't know. Logan asks says the Unforgiven Yuri, check your Discord. Frank Leslie says, regarding Chili, it's a fool's errand to try and convince someone who thinks they are the smartest in the room that they're not. I know. Logan Salmon says, hashtag clearly. Fox Adams says, yeah, 636 B1A or B doesn't help. Yeah, that's the authorizing language for the local rule. And yeah, it doesn't help. Fox Adams says, I'm kind of partial to 18 USC 111. Fox Adams says, doesn't help Floyd. Fox Adams says, not a bad one, Logan. Lol. Captain Clown says, look out for the skinwalkers. GMK says, can cock be reviewed de novo? In your case, sure. Bandit says, hello, good people. There's no good people here. Bandit says, what's really going on? Probably nothing of value. Orange Cone says, Jack Handy, bet you push the brakes. Bet you push the brakes when you have driven off a cliff. Hey, better try the emergency brake. Okay. Ron Youngblood says, I miss the good old streams when Chitler pulled out his teefers all the time. Bandit says, that was epic. Hopefully the murder investigation takes off equals people talking. Lurker1 says, thank you. Captain Cloud says, now I have to listen to some Grand Funk Railroad. Killer Kaiser, are you going to cover the me? Killer Kaiser says, Michael Kaiser murder investigation. No, I don't cover investigations. I'm sure other people will. I'm not on a private Kaiser crusade. He's a dipshit, and as far as I'm concerned, I'm not going to give him any more like dedicated coverage because why would I? Killer Kaiser says Donald A. Cameron was a war vet. Yes, he was. Kaiser says Frauder Wrangler equals Michael Kaiser. Yes, I'm aware. Killer Kaiser says murdered by a junkie playing Call of Duty. I'm aware. Killer Kaiser says, we got this, people. Let's solve a murder. You're not going to solve a murder. And people shouldn't get involved in it. Let the authorities do what the authorities do. Don't taint evidence. Biff Thundermuffin says, you can indict a ham sandwich, but a conviction is different. Absolutely. Mr. Sharbar says, how are you convinced that you can indict a ham sandwich? It is a common statement. And the reason why you can indict a ham sandwich is because at a grand jury hearing, only the prosecution presents evidence. And you have to remember that all they have to do is show probable cause. That is the level of proof that they have to show at the grand jury investigation. So you only have the prosecution presenting evidence, and all they have to show is probable cause. And probable cause, again, is a very low bar. They have to show the crime was probably committed, not like 51%, but like there's a substantial likelihood it was committed, somewhere below 50%. But they have to show that the crime was probably committed and this person is the one who probably did it. It's a very low bar. And if you only have one side presenting evidence, that really makes it easy. Biff says he's made thousands in donations from what folks have calculated. Well, that's not a lot of money. Mr. Shobar says, please identify a ham sandwich that has been indicted. My midwit jokes. Hoo-hoo. It's a fucking saying, bro. It's a fucking saying. Idiot. You fat dork. Killer Kaiser says, Donald Cameron deserves justice. The family and detectives only suspect one person. Please educate yourselves, please. No, like, relax, dude. Relax. You're coming across as a bit fucking pushy. How about you fucking relax? Devin says, hello, Merb. Good to see you. Good to see you too, Devin. Mr. Shobar says, can a ham sandwich have any criminal liability? Kaiser says, Shiz Happens did a great murder update tonight. Well, go watch it then. Devin says, much easier to indict in a grand jury when only the prosecution presents evidence, hence the ham sandwich analogy. Exactly. Mr. Shobar continues with his idiocy. Is a ham sandwich capable of mens rea? Are you? Kaiser's a bad man. Do the rules of evidence apply to a ham sandwich? No. Then why imply that they do? I'm not sure that most of the rules of evidence apply at a grand jury hearing. It's very relaxed. I mean, I can't speak for all 50 states or whatever, but I would presume that most of the rules are either relaxed or aren't in effect. I've never done a grand jury hearing, but I know it's pretty relaxed. Again, there's no opposition counsel in there, so no one's going to be objecting to anything. Yeah. Is there a special grand jury? Jesus Christ, like fucking idiots. If you record the police, chances are you will not get a wardrobe malfunction. Go be you, bro. Okay. Bandit asks, is Coda going live tonight? No idea. Mr. Showbar continues on. Mr. Showbar continues on. Victor says Kaiser has no soul. Mr. Showbar finally says something different. Cholito's lips turn white because of his fasting. Is that true? Alan says Cholito is teaching constitutional law live. I doubt that. Ryan says, yeah, but is he really, Alan? I don't think so. Alan says Cholito, 334,000 subscribers equals 178 watching at an hour and 20 live. Well, he buys them, obviously. Fixer says, fat dork stoners. Exactly. Devil Saint says, Chili buys baby carrots just to suck on them. Ouch. Rockchild of the 60s says, hi, Emerb. Finally caught your live. Well, hi to you, Rockchild. Ryan Youngblood says, last time comment. And the last time comment is Wilco says, I feel like a ham sandwich now. Thanks for watching. Have a great day.